Hello, and welcome to Legal Protections for Workers with Disabilities, presented by the California Civil Rights Department. Thank you so much for joining us here, whenever and wherever you are. So, a quick disclaimer before we get into the content for today. This guidance is for informational purposes only and does not establish any substantive policy or rights and does not constitute legal advice. This training is being recorded on November 7th, 2025, and so this information is based on the most recent guidance as of today, but it is all of our responsibilities to be aware of changing guidance and laws. An overview of today's presentation. We'll talk about the Civil Rights Department. We'll then talk about the main piece of law where this information comes from, which is called the Fair Employment and Housing Act. We'll talk about specific disability protections, navigating the hiring process as a person with disabilities, reasonable accommodations for people with disabilities, and then lastly, we will talk about some Civil Rights Department resources. So about the Civil Rights Department, our mission is to protect the people of California from unlawful discrimination in employment, housing, and public accommodations, and from hate violence and human trafficking. You may be familiar with us under our previous name, the Department of Fair Employment and Housing, but as you can see, the name change reflects more of what we do because we do so much more than housing and employment. So some of those responsibilities of the Civil Rights Department include investigating complaints of discrimination and other civil rights violations. Part of the Civil Rights Department process is to try to resolve those issues early, so to facilitate dispute resolution that involves civil rights violations. Sometimes, and rarely, we do prosecute violations in court. The Civil Rights Department also issues regulations that provide greater clarity about the laws that we have authority to enforce here at the Civil Rights Department. We also collect data on the pay and demographics of large employers' workforces. We do what I'm doing now, which is to conduct outreach and training to inform Californians about their rights and obligations under civil rights law. And we have a very unique unit here at the California Civil Rights Department that works exclusively with communities and state and local bodies to try to resolve conflict that has a community-wide impact. So a bit different from the more individualized complaints that you might be more familiar with. Now, our ability to do any of these responsibilities is based on our ability to reach folks where they're at. And so certainly for folks with disabilities, we provide accommodations so that they can participate in any part of the civil rights complaint process. Similarly, folks who speak languages other than English or who feel most comfortable communicating in a language other than English can also get assistance to participate in all parts of the California Civil Rights Department complaint process. So a quick note about definitions and terminology before we get started. Legal definitions may be at odds with or delayed in including evolving language and terminology. Consider using glossary resources directly from the disability community or disability organizations to ensure that you are using culturally appropriate terminology. The law is sometimes a little slow to catch up with evolving everyday language. There is some legal language in today's materials that are generally considered outdated or offensive by folks in the disability community. Those include the terms special needs, handicap, and impairment. I will use those words today, but only when quoting the law. I will otherwise use different, more widely accepted terms like disability and accessible. Now, before we get into the law, also a quick note here on why this is such an important topic. So you'll see some data and statistics here on your screen. Most Californians with a disability do work, but they work at lower rates overall than other working age Californians. So it's really important to understand how folks with disabilities can receive equal treatment in the workplace. We know from data and statistics that they are underemployed. We also know that disability is the largest represented minority in the United States. 1 in 4 adults in the United States report having some kind of disability. And that graphic and information comes from the Federal Center for Disease Control, and that was captured online in October 2024. You'll see too that various forms of disability are represented, from cognition and mobility down to self-care. So it impacts so many people. A quarter of the United States population may be entitled to some of these types of protections, depending on where you are. But we are right here in California, and so we're going to talk about the California Fair Employment and Housing Act, or FEHA. FEHA includes different protections for employees, including the rights of employees to take leave to care for themselves or a family member due to a serious illness, if they're disabled by pregnancy or a related condition, to bond with a new child, after the death of a family member, or after experiencing a reproductive loss. Additional FEHA protections include employment protections for people with criminal histories, and that's called the Fair Chance Act. There are also anti-discrimination protections based on employees' use of cannabis off the job and away from the workplace. There's also a provision regarding job advertisements and applications and other materials not being able to require applicants to have and provide a driver's license. There are some exceptions there. If the employer reasonably expects driving to be one of the main functions of the job, and the employer also reasonably believes that using some kind of alternative form of transportation, like public transit or a taxi or a bike, is not going to be comparable in terms of travel time or cost to the employer. So an important thing to note if you are an employer who advertises online or elsewhere. And then lastly, there are time off and anti-retaliation protections for victims of certain types of violent crimes and their family members. There's a required notice and accompanying frequently asked questions document that you can find on the Civil Rights Department website. So more about FEHA. In addition to what we just talked about, FEHA protects employees and job applicants from discrimination and harassment on the basis of one or a combination of protected characteristics. FEHA also prohibits retaliation. We'll talk about what that means. FEHA also requires that employers consider reasonable accommodations for disabilities and religious beliefs. Today we'll be focusing just on disabilities. And importantly, FEHA applies to state and local government employers and private employers who have 5 or more employees. There's one very important exception there in FEHA for harassment. FEHA says that employers of any and all sizes are prohibited from harassment. So even if FEHA may not apply to an employer in terms of discrimination or retaliation, it will apply in regard to harassment. Now, what is a protected characteristic? That's some kind of personal trait, belief, or something about a person or group of people that makes up an important part of their identity and which is recognized and protected by the law from discrimination and harassment. So we are here to talk about folks with disabilities. The law protects people from discrimination based on disability, and that makes disability a protected characteristic. I know it says share in the chat here on your screen, but think about other protected characteristics that you might be aware of. There are a lot of employment protected characteristics here in California. We're going to focus today on disability, but I do want to make a quick note here about medical condition, which is also covered by FEHA. The way that the law defines medical condition is different from the way that we tend to use it in everyday speak. I think in a lot of circumstances, medical condition and disability are terms that get used interchangeably, but the law defines them and looks at them a bit differently. So a medical condition is defined as any kind of health impairment that's related to or associated with a diagnosis of cancer or a record or history of having cancer. It can also include genetic characteristics or inherited characteristics known to cause a disease. So it's a very specific definition in FEHA. So think about how those definitions may be different and certainly consider the difference in those definitions if you are a person who is pursuing an employment discrimination complaint. Also want to point out here that FEHA includes protections for perceived characteristics. So the mistaken belief that someone does have one of these protected characteristics. The law does not want to make it okay for employers to discriminate against folks just because they're wrong about who they're discriminating against. FEHA also covers association with folks who have protected characteristics. That's kind of just what it sounds like. If you associate with somebody who has a protected characteristic and experience discrimination or harassment as a result, then that is also covered by FEHA. So we've just defined medical condition. Let's define disability. So in California, disability is defined as a mental or physical impairment that limits a person's ability to perform a major life activity. And major life activities include physical, mental, and social activities, especially those that affect a person's ability to be employed or otherwise present a barrier to employment or advancement in their career. Disability can also be defined as having a record or history of a disability, including previously having or being misclassified as having a record or a history of a disability. We just talked about perception under FEHA, and here in the definition of disability, that is also covered. So disability may also be defined as having a perceived disability or being regarded or treated as having had a disability. And then lastly, any other recognized health impairment or mental or psychological disorder that requires or has required in the past special education or related services. Typically, we are working with that first definition, a mental or physical impairment that limits major life activities. So let's talk about major life activities. What might those look like? Could mean physical activities of daily living, like walking, eating, reaching, or lifting. Could also mean psychological or cognitive activities, like learning, thinking, interacting with others, or concentrating. It can also refer to how a person's bodily functions operate, such as their respiratory system or their immune or digestive systems. Now, the law, in addition to defining disability, also creates some exceptions from the definition of disability. So some exceptions include compulsive gambling, kleptomania, pyromania, psychoactive substance use disorder that results from current drug use, and sexual behavior disorders. Now you'll notice that current is underlined here, and that's because if a person has used psychoactive substances in the past or has a disability that arises from past drug use, but they are no longer using that drug, they still may have a disability, even if it arises from something that maybe was an exception. Another exception here, mild conditions that don't limit major life activities are not considered disabilities. So conditions that might have little to no lasting effects. Obviously, folks are very unique, and so their disabilities may also be very unique, including how those disabilities interact with perhaps other disabilities or with their regular bodily functions. So really, really important that we always think about disability and these exceptions in that kind of context, right? Very unique. Reasonable accommodations, also unique and responsive to people's disabilities. We'll get into it. So I want to talk about Anna. Anna is a cashier at a lumber yard, and she has a back injury from a car accident that happened when she was a child. Her injury sometimes flares up and causes difficulty standing for long periods of time. Other times, with the use of medication, standing isn't a problem. So Anna asks for a stool to sit on when working as a reasonable accommodation, and she mentions that her back tends to hurt more when it's cold, like during the morning shift before the building heats up. Her manager responds that Anna doesn't look or act disabled because she mostly manages her pain with medication. The manager does agree to provide a stool during flare-ups as a favor because the employer, the manager, doesn't want to open the request floodgates to everyone else. So let's think about Anna's situation based on what we just learned. Does Anna have a disability despite being able to perform major life activities and managing her symptoms with medication? Yes. The ability for someone to manage their symptoms does not mean automatically that they are excluded then from that definition of disability. Now, can Anna's employer insist on only giving her a stool during these flare-ups of Anna's disability? No, that would be inappropriate. So keep Anna in your mind because we are going to come back to her in just a little while. Let's now define and talk about some examples of discrimination, harassment, and retaliation. FEHA defines discrimination as treating a person differently, at least in part, based on one or a combination of protected characteristics. Harassment refers to unwelcome words or behavior based on a protected characteristic that threatens, intimidates, embarrasses, or demeans a person. It may also have an impact on their sense of personal safety at work. And lastly, retaliation occurs when an employer punishes an employee or treats them unfairly, at least in part, because they exercised a protected legal right. They did something that they had a legal right to do. So now that we've defined these terms, let's talk about how they might come up at work in regard to people with disabilities. So some discrimination examples might look like refusing to hire people with disabilities, or demoting or assigning a person with a disability to a less desirable shift. It could also mean asking about a person's disability during a job interview, or using hiring technology that unfairly screens out people with disabilities. Lastly, discrimination could also look like failing to provide a reasonable accommodation to an applicant or employee with disabilities. Now, what might harassment look like at work? That could look like teasing, jokes, or slurs about people with disabilities, or which target a person with disabilities. It could look like physically blocking someone from their workstation, or forcing a person to do work that aggravates their disability. It could also look like hiding or interfering with a person's assistive device. So perhaps they have something that helps them do their job, and so interfering with that device is also a form of harassment. Lastly, retaliation. Remember, this is punishing an employee for exercising a protected legal right, doing something that they have a legal right to do. That could look like filing a civil rights department complaint, requesting a reasonable accommodation based on disability, telling a supervisor about experiencing or witnessing harassment or discrimination, cooperating with an investigation into workplace harassment or discrimination, or contacting a lawyer or a nonprofit for advice or to learn more about harassment or discrimination. So now that we've defined these terms and we have a sense of how these might appear at work, let's talk about Theo and his experience. Theo is a military veteran and he experiences post-traumatic stress disorder, or PTSD. He is proud of his service and he's open about his condition to raise awareness about veterans' mental health. Theo's applying to work as a package delivery driver. He previously worked a similar job and he has a spotless driving record. He gets an interview and he's very optimistic. At the interview, Theo mentions his disability while discussing some of his volunteer work. The interviewer stops him and says, this job is really crazy. We're on our third driver this year. I'd hate for you to have an episode and get fired, but I have an idea. Let me interview you for a position in the storeroom instead. It's quiet. That'll be such a better fit. You'll love it. Let's think about Theo's experience. Did the interviewer discriminate against Theo? Yes. In this circumstance, likely this was discrimination because immediately after learning about Theo's disability, the interviewer tried to persuade Theo to take another job, essentially ending the interview for the driver position. The interviewer made some assumptions about Theo's disability symptoms and accommodation needs just based on learning that Theo has a disability while he was talking about volunteer work. This also discounts that Theo had a similar job before and has no negative driving record. So a couple of places here where the interviewer went wrong, and I think an important lesson to take from this is that good intentions can still lead to liability. So even though this interviewer may have been trying to be helpful, they made some assumptions about Theo's disability and denied him a job as a result. Now, any other issues here with the interviewer's conduct? This probably does not rise to the level of harassment, but the interviewer showed a real lack of awareness using the term crazy right after learning that Theo has a mental health disability. So a little bit of thoughtfulness there from the interviewer could have made this a lot better of an experience for Theo and for the interviewer. On that note now, let's turn to talking about navigating the hiring process. So we will start with job applications. Employers must consider and accept applications from all applicants. Applications also cannot ask for information about a person's disability. And related to this, generally, applications can't require photographs because photographs may reveal information about protected characteristics or categories like disability, which employers are not entitled to know or consider when they are making employment-related decisions or considering applicants. Another important piece of information about job applications. There's increasing use of online and automated applications, and so employers must use caution with online application technology that limits or screens out applicants based on their schedule. And this is because it may have a disproportionate impact or a larger and negative impact on people with disabilities. And that would amount to disability discrimination. So using that kind of online technology to screen folks out based on their schedule is illegal unless it is job related, necessary to the business, and the application technology includes a way for applicants to request an accommodation based on their disability. So employers should carefully read the features and user agreements to make sure that the technology that they are using follows this California law. Now, what about job interviews after the application stage? Employers are required to provide reasonable accommodations to job applicants with disabilities. So an example might be providing interpreters for people who are deaf or hard of hearing, or installing screen reading technology on equipment that's required for in-person writing exercises for applicants with low vision. Now, during job interviews, employers cannot ask questions about an applicant's disability at any time before the job offer is made. This does not mean that employers can't ask about whether a person can perform the essential functions of the job, the main and most important pieces of the job. Certainly, employers can ask whether or not applicants can do all of those functions. But they must also clearly communicate that applicants don't have to disclose scheduling restrictions based on their disability, religion, other protected characteristics. So some questions that employers cannot ask. Do you have any particular disabilities, or have you ever been treated for these following diseases or conditions? What prescription medication are you taking? Have you ever left a job because of a physical or mental limitation? Have you ever been hospitalized, or have you ever taken medical leave? Those would all be prohibited questions, right? Because they're trying to get at a person's disability. This last one, I want to spend a little bit of time on. Can you see any reason you'll need leave in the next 6 to 12 months? Now, that question on its face may seem appropriate because, unlike the other questions here, it is not explicitly asking about disability. But while the question is not explicitly asking about disability, that question may be crafted to get an applicant to provide information that otherwise the employer is not allowed to consider. So an employer could ask a question like this, so long as they also make sure to let the applicant know that they are not required to disclose any disabilities. So an employer could ask instead, other than time off for reasons related to your religion, a disability, or a medical condition, are there any days and times when you're unavailable to work? That would be a perfectly fine question for an employer to ask. Now, what about disclosing a disability? Not every disability is going to require a job-related accommodation. We know that because we talked about that regarding Theo and his experience. So whether an applicant or employee discloses a disability is their personal decision. Applicants and employees may disclose their disability or disability-related needs during the job interview, after a job offer, or starting the job, to support a request for some kind of job leave, or when requesting accommodations. And in some circumstances, disclosure may be required. Now, when disclosing a disability, an applicant or an employee should tell at least one person who represents the employer. So someone with some kind of authority to make the reasonable accommodation process start and happen. So that might mean a manager or a human resources representative. It's important here to know that it's not necessary to provide a medical diagnosis or extensive details when disclosing a disability. Now, if requested and required by law, people are only required to provide enough information or documentation to support that they need that particular accommodation. So it's not a lot of broad information. It's not medical records necessarily, but something that makes very clear that there is a connection between the person's disability and the disability-related need that they have. And important to know here that no documentation is required or should be requested when a disability is obvious. So for example, if a person uses an assistive device because they have a mobility-related disability, that would be an obvious disability, and it would be inappropriate to request documentation to support that this disability exists. So let's now talk more squarely about reasonable accommodations. Now, a reasonable accommodation at work is some kind of modification to the workplace that can ensure a person with a disability can perform the essential functions of their job and also enjoy the same benefits and privileges of employment as their colleagues who do not have disabilities. And California law requires employers to reasonably accommodate employees and job applicants who have disabilities. Now, how do we determine what is an essential function of a job? Unfortunately, the law does not provide us a definitive list, but the law does provide us some factors to consider in figuring out whether a job responsibility or task is essential. So some examples might include the employer's judgment, also the job description or collective bargaining agreement. What does it focus on? Maybe time spent performing that function. Is it a function that takes up most of the job time? The legitimate business consequences of not performing that particular function. Can also look at the work experience of past or current employees in similar jobs. What do they spend their time doing the most? Could also look like reference to the function in a performance review, because that would indicate that it's an important piece of the job if it's being reviewed. And now a note here again, no one of these factors is going to be controlling, but these are some factors that you can consider. And I want to make a point too here. The opposite of an essential function, we'll call that a marginal function. You'll see that down there in the note at the bottom of your screen. So if it's not an essential function, it is a marginal function, which means it's just not essential. So we've defined reasonable accommodations. We have a sense of how we can understand essential functions and accommodations for those functions. Let's look at some examples of reasonable accommodations. Could look like physical modifications to the workplace. Maybe it's providing equipment or assistive technology to folks, or allowing an employee to bring their assistance animal to work. It could also look like changing a shift, relocating a person to another area or work site, reassigning a person to a different vacant job. Maybe it looks like restructuring a job so that a person has uninterrupted time to get particular tasks done. Or maybe it's reassigning those marginal functions to someone else. Could also include telework and many, many more accommodations. Reasonable accommodations are very unique and they're going to vary by person. Now, what about requesting a reasonable accommodation? Those can be requested by applicants or employees at any time. And they should direct their reasonable accommodation requests to someone with authority. So a supervisor, a manager, human resources, making a disclosure to a colleague and saying, gee, I really wish I had this accommodation for my disability, is not going to trigger any required action by an employer. Importantly here, when we're thinking about how to request accommodations, there are no magic words that a person has to use to request an accommodation. They just have to make clear that they need some kind of change at work based on their disability. There's also no limit on the number of accommodation requests that a person can make. Requesters have to provide enough information to show a connection between their disability and the requested accommodation, and that connection is called a nexus. Requests can be made verbally or in writing, and important to know and consider here is that employers actually cannot require applicants or employees to complete a specific form. Certainly, documentation is helpful to everyone, but if the employer wants a specific form completed, they can certainly do that themselves. They cannot require that the applicant or employee do that, and especially can't require that an applicant or employee do that before the accommodation request will be considered. And what happens when a request is made is that it triggers what's called the interactive process. And you can think about the interactive process like a good faith negotiation. It's an exchange of essential information about what the applicant or employee needs, and it can include brainstorming about that person's needs and limitations. Now, regarding requests for medical records, during the interactive process, employers can ask for proof from a healthcare provider that the applicant or employee has a disability. Now, that information does not need to include a specific diagnosis. It should not include a blanket or big and broad request for medical records. Medical records are typically very technical and not helpful. And a request can include, though, proof that the person has a disability that limits their major life activities and a list of what activities are limited. Could also include suggested reasonable accommodations. And again, we talked about this just a couple of slides ago, but employers should not ask for medical documentation when a person's disability is obvious and the need for the accommodation is clear and obvious. So an example here might be a person who uses a wheelchair requesting an adjustable desk, one that goes up and down, or a person with a prosthetic hand asks for speech-to-text technology for typing. So in these circumstances, the disability is observable, it is obvious, and the need for the accommodation is similarly pretty clear, pretty obvious. That connection, that nexus is really clear between those things. So in those circumstances, employers really should not request any medical records because, or any information or medical documentation because it's pretty clear what that person needs. Now, what about evaluating how well a reasonable accommodation is working? So if an employer provides a reasonable accommodation and it isn't effective, or maybe over time it stops being effective, then we jump right back into that interactive process. It is really important to note that that is an ongoing process. If there are issues with the accommodation, if there are questions, it all goes within that interactive process, that good faith negotiation and discussion. Definitely keep those lines of communication open, and a best practice might be to set regular check-ins on how effective an accommodation is. Now, there are circumstances in which employers can deny a reasonable accommodation request. Employers do not have to grant an accommodation request if doing so would pose an undue hardship on the employer. Now, that means a significant difficulty or expense considering that particular employer's resources. So very fact-specific, different sized employers are going to have different resources and different capabilities. Some factors to consider here might be the size of the employer, the type of the employer, and the accommodation requested. Now, it is the employer's responsibility to show that the accommodation as requested would pose an undue hardship. Similarly, employers do not have to grant an accommodation request if doing so would endanger the health and/or safety of the applicant or employee or other folks at the workplace. Any kind of analysis of a threat to health or safety has to be based on objective evidence and the most current medical evidence from that person. And any kind of danger or threat has to be immediate and serious. It can't be a hypothetical or future risk. There are some things that employers are not going to be obligated to do or to provide as a reasonable accommodation in any circumstance. Now, those are going to include providing assistive equipment for a person's personal use while they are not at work. So perhaps a vehicle lift for their personal vehicle. Employers are also not required to change an employer's supervisor or create a new position. They are also not required to lower a production standard that's consistently applied to other employees with the same job title. They're not obligated to eliminate an essential function of the job, so the main part of what the job exists to do. And they are also not obligated to grant an indefinite leave of absence, though certainly asking for the extension of a leave of absence is a reasonable accommodation request. When employers are thinking about undue hardship, many times the cost of the accommodation comes up. And so we thought it would be helpful to share some data from the Job Accommodation Network from 2019 to 2023 on the average cost of workplace accommodations. A little more than half, so 56% of accommodations don't cost a thing. They are $0 and 0 cents. 37% of accommodations on average had a one-time cost with a median of $300, which over the span of a person's employment may be a pretty insignificant sum. And then 7%, so the smallest proportion, have an ongoing annual cost with a median of almost $2,000, $1,925. So really important to consider here that you can be very creative during the interactive process, and it does not always involve spending money. Most don't. Now let's return to Anna. Remember Anna from the top of our time together. Anna had asked her manager at the lumber yard for a stool as a reasonable accommodation for a back injury. And she mentioned that her back hurts more when it's cold in the lumber yard building. Now, recall too that her manager said that Anna isn't actually disabled, but nonetheless agreed as a favor to allow Anna to use a stool when she has flare-ups, so the manager isn't flooded with similar requests. Anna attends a webinar, perhaps watches it on YouTube, and learns about disability rights and accommodations. Anna thinks that her manager violated her rights, especially related to her accommodation request and the interactive process. Think for a moment what we just talked about, and then let's think about Anna's situation. How did Anna's employer mishandle her accommodation request? We'll go through 4 reasons here. First, calling the request a favor. Anna has a disability, and her employer has obligations under FEHA not to discriminate against her and to follow the reasonable accommodation process. It's not a favor, it's the law. Second, stating that Anna isn't disabled instead of requesting proof. Anna's disability isn't obvious. It's back pain, but Anna does not wear a back brace or walk with any assistive mobility devices, and so it's not obvious. And instead of telling Anna that she isn't disabled, which could possibly be harassment, Anna's manager can just simply ask for proof that Anna's back injury limits her major life activity of standing. So instead of getting caught in a trap of potential harassment, Anna's manager, they knew the rules, could just have asked, hey, your disability isn't obvious, so can you help me understand and provide some documentation to support that request and your disability related need. Third, here we have failures in the interactive process, which is what we were just talking about. Anna's manager didn't acknowledge Anna's statement about the cold or explore any other accommodations with her, like maybe changing Anna's shift to the afternoon or moving her to another register. They could have brainstormed together and maybe come up with an accommodation that wouldn't have cost anything, if in fact they had to spend any money on a stool. And then lastly, denying the accommodation request to avoid a flood of requests. This is not allowed. Employers cannot use a hypothetical future accommodation request to deny a real current request. Every request has to be considered on an individualized basis. And so an employer saying, if I grant this to you, I will have to grant it to everyone, is not an appropriate or legal reason to deny someone's accommodation request. So I thank you for your attention during this part of the webinar recording. I want to leave you with some resources from the California Civil Rights Department that you can access after watching this recording. We have a ton of written resources, helpful to employers and also helpful to employees. We have a harassment prevention guide, for example. We also have fact sheets and frequently asked questions documents on things like pregnancy disability leave and disability discrimination in employment generally. I appreciate that you're here watching this on YouTube. And if you'd like to join one of our live webinars, we have 3 webinars a month. They happen on Wednesdays. Visit CRD's website to sign up for all of our offerings. And you are here on YouTube, and so I would encourage you to poke around in the other video resources that we have here. We record a ton of our webinars and content. We hope it'll be helpful to you to access. And thank you again, a final thank you for coming to our channel and learning about the rights of employees with disability. Thank you whenever you are and wherever you are. We appreciate you.